Well, good morning and welcome to our webinar today, where we're talking about redundancy and furlough. We're going to run this as a Q&A format. I'm delighted to be joined by David Finn, who's your host today. He's joined by Parish and Ricky from RDP Newmans, both partners, welcome. And we're joined today by Fiona Howarth, who is an employment specialist from Practical HR. So, without further ado, we'll move on into the format. If you do have any questions as we go along, if you look at the Q&A tool that's in your Zoom toolbar, please use that panel to put any questions forward that you might have, and we'll try and answer as many of those as we go along. So at this point, I'll hand over to you, David.
Thank you, Jo. By way of introduction, as many of you are no doubt aware, the Coronavirus Job Retention Scheme, known to its friends as CJRS, came into place early on in the COVID cycle in March, and is in place and will remain in place until the end of October, as many of you may be aware. Yeah, the purpose of the scheme was to avoid the need for redundancies. Yeah, however, it is accepted that businesses will not simply resume to the levels overnight to which they were prior to COVID, and it's likely to take time, and therefore jobs will still be at risk during this period, and the industry generally is very fearful as to what may happen once as CJRS finishes, whether redundancies will then be made. The idea of bringing employees back on a part-time basis from the 1st of July was designed to enable a gradual and safe return to work, thereby avoiding any cliff edge cut off when the scheme came to an end. But unfortunately, this will not be a save-all solution, as many of us will know. To help you and us understand the redundancy process and discuss options that are available, we're joined today by two of my partners, Parish and Ricky, both of whom general practice partners, both of whom are responsible for the HR in RDP Newmans, and have a varied and wide portfolio of clients, all with various HR needs and furlough needs, etc. We're also joined by Fiona Haworth, who is an independent HR consultant. Fiona has over 70 years, I do apologize, Fiona, 30 years experience in HR. She's spent the last 16 years working as an HR consultant, supporting clients through a wide variety of employment issues, including restructures, redundancies, TUPE transfers, disciplinary and grievance matters, long-term absence, etc. Prior to working in consultancy, Fiona spent 15 years in numerous HR and management roles within the financial services sector. Okay, so let's start off, if I may, with you, Ricky and Parish. We, like many others, were thrown at the deep end when furlough first came out. What are your experiences of working with our clients, and how have they used CJRS, the job retention scheme, and what do they intend to do when this comes to an end?
Thank you, David. Yeah, I mean, the job retention scheme was a very necessary tool that the Chancellor sort of made available. It did, without doubt, preserve jobs in the initial phase of the lockdown. Many clients, particularly in the retail and the restaurant trade that we act for, it was a very necessary lifeline to ensure that the staff actually were paid something and were able to meet their own commitments like rent, food, and et cetera, et cetera. So it delivered on that front. There have been challenges for these businesses, because obviously the retention scheme was not sufficient and not the only tool available, and the other grants and supports that many of these businesses have, the bounce back loan, etc., have all, as a broad spectrum of support, helped these businesses sort of get through the first 3 or 4 months.
Ricky, can you comment as to how easy it was or otherwise to obtain the furlough monies?
Yeah, well, I mean, I think, in a way, David, you've got to cast your mind back to sort of March, April, when this was introduced. It was a very difficult environment for us all. lack of visibility, a lot of uncertainty. Clients were struggling, and with that backdrop, as Parish has quite rightly said, it was an invaluable support, almost a lifeline for certain clients. The process itself, clients were in a difficult position commercially. They had, on one hand, they had loyalty to staff. On the other hand, they had to run the business. The process itself, there were teething issues, lack of information, lack of guidance, but it was adopted fairly, the use of it was fairly widespread amongst our client base, and with help from our payroll team, they got through it in the main.
What have we come across in terms of complex issues that we've been able to solve through the furlough scheme, Parish?
And one of the key issues around that sort of March 23rd, whenever the lockdown happened, was the furlough scheme was only available for employees who were on the payroll prior to the payroll being run. One of the issues we had was that like many owner-managed businesses, and for various good tax planning reasons, payrolls only run once a year, an annual payroll, typically for directors. And if the payroll hadn't been run before the furlough was introduced, they were initially rejecting any furlough claims. And that did involve a fair amount of time on the phone with the HMRC trying to get that resolved. And eventually, for most clients, that was resolved, but it did cause a bit of stress to some of these clients. And obviously, they were expecting and relying on this cash flow. But as Ricky was just saying, that on the whole, through the hard work of the payroll department and just persevering, we got through that initial sort of teething problems. And obviously, then since May, June, things have been very much more settled. Obviously, the next challenge that came along was the gradual return to work of some of these employees, but not full time. So the flexi furlough, and that also, again, we had a few teething problems in terms of systems and software updates, etc., from our providers. And again, we've managed to meet that challenge and get through it. And again, seems to have settled down. The practical issues still remain in terms of clients keeping good records of staff and the hours they work if they're on flexi furlough. Because all this, and I think we will cover it later on in the discussion, will be subject to HMRC review. It's very much been publicised that they will be looking at some of these claims very carefully, and the validity and the support information will need to be there.
Okay. We understand that unfortunately furlough, although a lifeline, may not be enough for some businesses. And perhaps, Fiona, we can turn to you now, looking at there are going to be some businesses at the end of furlough or even during furlough will need to make redundancies. Yeah. What are the potential implications of making redundancies whilst employees are still on furlough?
Okay. Well, the government actually recognises that employees may still need to or want to make redundancies whilst employees are furloughed, especially now the employer is having to contribute towards the scheme. So if redundancies are made whilst the scheme is running, the good news is that the government have confirmed that an employer can continue to claim the furlough for furloughed employees who is serving a statutory notice. So although the grant can't be used to substitute the redundancy payment, it can be still used for the notice period. Although this can't be done if you're making a payment in lieu of notice. So during the notice period, you would have to leave your employees on furlough.
How should a business establish whether there is a genuine redundancy situation?
Okay, so for it to be a genuine redundancy, it's got to meet the definition of a redundancy. So referring to the Employment Rights Act, it says that an employer should be taken as being dismissed by a reason of redundancy if the dismissal was wholly or mainly attributed to the fact that the requirements of the business for an employee to carry out the work of a particular type has ceased or diminished, or expected to cease or diminish So what that's basically saying is that an employee's particular function has disappeared or reduced, or the situation arises where jobs can be amalgamated. So as long as it meets that definition, then it would be a genuine redundancy situation.
What is a selection criteria exercise, and can you give us some examples? We understand that's part of the redundancy process.
Yes, so where you've got a number of people carrying out a same or a similar job function, or have the same job title, the company will have to justify why they're selecting a particular employee or a number of employees for redundancy. Now, a selection criteria exercise must be objective as possible. So this means that where possible, you should use factual data. For example, how many days absence somebody has had, looking at their disciplinary records, whether you've got previous appraisals, looking at key performance areas and the skills that you require for the job moving forward.
Okay, again, another term we've heard banding about, and certainly we've seen it in the news, the big companies making wholesale redundancies. What is a collective redundancy, and are the rules different there?
Yes, the rules are very different to if you're making less than 20 employees redundant. So if you are contemplating making 20 or more people redundant in a single establishment within 90 days, this is where it's called a collective redundancy. And I would emphasize the fact of in a single establishment. So if the company has got a number of different offices and you're making redundancies in each of those offices, locations, it's about the number of people in a single establishment. So if you had 10 people in one establishment, 10 people in another establishment, that is classed as a normal redundancy. If they were all in one location, that would mean it's 20 people, and therefore collective redundancy would apply. Now, where the process is different from making a normal redundancy, you would have to submit an HR1 form to the redundancy services before consultation starts. That's to just advise the government that there is going to be a large-scale redundancy in a particular area. You would also have to elect employee representatives, and the consultation period would be a longer period. So if you're making up to 100 people, or sorry, up to 99 people redundant, the consultation period would have to be 30 days before any dismissals can be made. If it's over 100, then it's 45 days. Now, a collective redundancy could arise where there's actually less than 20 people are being dismissed, but if the possible number of people could be. So even if the number could be 20 or more, but because you're making potential adjustments to it. So let's say, for example, you've agreed with some people that they would reduce their hours, you would still have to class those as being in that pool of being 20, so collective redundancy would apply.
Okay. On a regular redundancy process, if there is such a thing, can you sort of explain the key steps that the employer should look out for, make sure that they comply with?
Yes, certainly. A redundancy process has a number of steps and stages. So first of all, the redundancy must fall within the definition of redundancy, which I talked about a moment ago. The company has got to consider whether there's any other alternative employment. A fair selection criteria must be used when selecting employees for redundancy, and employees must be consulted about possible redundancies, which will include informing the employees they're at risk and considering any suggestions or alternatives to redundancy that the employee may put forward. In addition, employees who are made redundant must be paid payments that are due under statutory redundancy and their contract of employment. Whereby I talked in the collective redundancy about periods for consultation. There's no legal length of time specified where there's less than 20 people being proposed as being made redundant. But we do see in case law that an employment tribunal would look at being a reasonable period of 2 weeks rather than a shorter period.
Okay. Again, useful for employers. How does an employer avoid a case of unfair dismissal in the redundancy process? How make sure it doesn't go wrong?
Yes, unfortunately, nobody can stop an employee taking you to an employment tribunal. However, by following a fair and reasonable process, this would stand you in good stead. So when doing the selection criteria, document why you're giving the scores that you have, what data was used, and what you looked at in that regard. And remember to take notes of all the meetings with the employees. And finally, ensure that the employee is paid what they're contractually entitled to, i.e. notice as well as holiday, in addition to the statutory redundancy payment.
Okay.
I'll just mention, actually, I think the compromise agreement does afford protection there.
Settlement agreement, sorry.
Sorry, settlement agreement.
You're on the correct.
Yeah, sorry, absolutely right. Yeah, that does afford some protection to the employer, you know, in this process, and it's worth considering, depending on, you know, how the process has evolved.
Can you elaborate on that for the audience? What does that mean? What is it? What document, etc.? Okay. Fiona?
So a settlement agreement is a legally binding agreement between the employer and the employee, which means that the employee will be signing away their rights to bring a claim in the employment tribunal in receipt of, it's usually a financial award for doing that. So it's an ex gratia award over and above what they're already entitled to. Now, for it to be legally binding, the employee will have to take legal advice, and the employer is obligated to contribute towards that. They don't have to pay the whole fee, but they are would be entitled to, or would be obligated to make a payment towards it.
Fine. Finally, assuming we've done all the steps correctly, how is the redundancy pay calculated?
Okay, redundancy payments are based on age and length of service. So first of all, an employee must have 2 years continuous employment before they're entitled to a redundancy payment. After that, the employee will be entitled to half a week's pay for each year of employment between the ages of 18 and 21. Following that, between the ages of 22 and 40, they're entitled to 1 week's pay for every year of employment, and over 41, it's 1.5 weeks pay over the age of 41. Now, there are some conditions around that. So employment ceases to be counted after 20 years service. So if somebody's got more than 20 years service, it's capped. You don't go over 20 years service. In addition, a week's pay for redundancy purposes, it's capped at £538. So if an employee earns less than £538 in a week, it would be their actual week's pay. However, if the employee earns more than £538, the maximum payment per week would be the £538.
Okay, lovely. Let's turn to you, Ricky, if I can. Yeah. We've got these redundancy payments. Tell us, how can a business plan their cash position around redundancy payments?
Thank you, David. Yeah, look, it's an area where businesses need to be very careful. Take advice, start the process early in terms of planning. Do make sure you have covered the alternatives. If reduced hours doesn't work and we're in this situation, you know, a robust budget, you know, it almost becomes, you know, it sounds very mechanical, David, but a payback period. And you know, whilst you're dealing, I do appreciate you're dealing with employees and, you know, real people, a robust budget which builds in, you know, also a bit of a buffer, make sure discretionary costs are curtailed as far as possible. Any commitments are short-term in duration, and flexibility. If you think you may need that financial support from a bank, make sure these plans are put into place early.
Okay. Are there any, I'll open it to Fiona first then, are there any alternatives a business can consider to redundancy? And how do these affect employment contracts as they may exist?
Okay, so companies will need to look at whether, apologies, I've just got a dust cart pulled right outside my window, so apologies, I'll speak a bit louder. So it's about looking at whether there are other ways to save costs within the business. So that's about removing company cars, benefits, reduction in hours or reduction in salary. However, you would have to consult with employees and get their agreement to do that. So remember, if you do get their agreement, to put it in writing to the employee and get them to sign a copy of the letter to indicate their agreement, so that any disputes at a later date about what's happened can be referred back to.
Okay.
Sorry, one other thing.
Sure.
You can also look to see if you're, whether in your contract you've got a short time working or layoff clause in there, which may give a buffer as to what you can do going forward.
Okay. Parish, we were speaking about furlough before and claiming monies back from government. Have we had any instances yet of the revenue challenging furlough payments or questioning the manner in which they've been calculated?
Haven't had any personal experience, however, or within our client base that I'm aware of, but however, it has been very well publicized by the government, HMRC, that they are aware that the whole mechanism of furlough coming in and as a support package, there were not very robust checks around legitimate claims, and that they will go back and revisit these claims and will essentially prosecute for false claims. And we are now beginning to hear HMRC now actually instigating these investigations, and cases have now come to light where claims have been fraudulently made, or at least they've been checked. So again, I go back to the point I was making earlier that employers are under an obligation to ensure that they do keep robust records supporting their furlough claims, particularly where you have a situation of flexi furlough or staff coming back in phases, to ensure that they have appropriate records of days, hours worked, etc. I suspect that they would expect to see those records being maintained.
Okay, I think, has anybody on the panel got anything further they would like to contribute that which you haven't touched upon? I mean, I know this is a very broad subject and each case is different, and we would encourage anybody in the audience who may have an issue of redundancy or indeed furlough claims to consult experts if you've got any problems. If anybody in the audience has any questions which they'd like to put to the panel, could you possibly do them now through the Q&A button at the bottom of the screen? No, it doesn't appear anybody has got any questions. Okay, on behalf of everybody here, we'd like to thank you very much. We hope that you found this little discussion useful. We hope that you don't need to make use of it, but if you do, please do make sure that you do it correctly. Many thanks to you all. Enjoy the rest of your morning. Thank you.
Thank you.
Thanks, David.